Hello and welcome to Meraki HR's Employment Law Update for 2024. My name's Emma Browning and I'm the founder of Meraki HR. We've been helping SMEs to attract, manage and retain great people for their business for nearly 10 years now. And here's a little bit about my background. So I have an HR degree and I have a master's in the management of innovation and change from both of those are from Oxford Brookes University. I spent the first 14 years of my career in sales and operations, and I've spent the last 24 years in HR working for some really well-known brands like Porsche Cars and Harley Davidson. But I've also worked for a small number of SMEs in manufacturing engineering. And obviously, in the last 10 years, we've predominantly been working with SMEs across a variety of sectors. I left the corporate world at the end of 2014 to set up Meraki HR. And my passion is really about helping ambitious SMEs to start up or scale up their business. We love to see businesses grow and succeed through managing their people successfully. So, what's changed? Well, we're going to provide you with a summary of what's changed as qualified HR professionals, but we're not employment lawyers. So this is a high-level summary of employment law changes that will come into force in April this year. And it's based on our research and our understanding of these changes, and it has been checked by the employment lawyers that we work with. Each business that we work with, though, is unique and is different, and we would be happy to advise you of any employment law changes specific to your business. Just get in touch with us directly if you have any questions about anything that we share with you in this session. But you can also get in touch with us to attend our Ask Me Anything session, which we're holding on the 28th of March, which is specifically about these changes coming into force in April. So if you've got any questions, just drop us a line and we'll book you onto one of those Ask Me Anything sessions. So the first change I'm going to talk to you about today is something that happens every year. So I'm sure you're well aware of these changes and are very prepared for them, but just in case you aren't. The first one is about minimum wages and statutory payments changing. So they change every year without fail. And these rates are all applied as of the 1st of April 2024. So the national minimum wage is the minimum pay rate per hour, which all workers aged between 16 and 21 are entitled to. Now, the government reviews these rates every year and is advised on the levels to set the minimum wage by the Low Pay Commission. The minimum wage for workers 21 and over is called the national living wage, and many employers are now choosing to pay this to their employees, irrespective of their age, to attract the best quality of candidates. Now, it's interesting, isn't it? Because some of these increases are quite significant. And as a small business, if you're like me, you're looking at your costs at the moment, and you'll be looking at that thinking, wow, that's a big increase. And the Low Pay Commission attributes the size of the increases this year to the robust growth in pay just generally across the economy in the UK. However, the increases have stopped short of the voluntary real living wage, which is set by the Living Wage Foundation. And just for your information, in case you're not aware, that's currently set at £12 across the UK, but £13.15 an hour in London. What we're finding is that employers are having to pay the national minimum wage for all workers just to attract the best candidates, as we've said. Now, there is a risk if you don't pay your staff at the appropriate rates. You do risk claims from your employees, but you could also now be named and shamed in the government report. It's important, therefore, that you keep abreast of the increases in pay rates, and in particular, check that all of your staff look at their ages, particularly if they're 21 or under, and make sure you're increasing their pay rates as they go up those ages. And this is often something that we see clients falling short of and unfortunately falling foul of. So if you need any help or advice with minimum wages and how to check those, do please get in touch. The other increase, of course, that happens is all the other statutory payments that you have to make. So the weekly rate of statutory maternity, paternity, adoption, shared parental leave, and parental bereavement leave increases to £184.03 per week, or 90% of the average weekly earnings, whichever of the two figures is the lower. The weekly rate of statutory sick pay increases to £116.75. And the only other one we normally tell you about is the statutory redundancy pay per week. However, those rates haven't been published yet, so watch this space and we'll let you know as soon as we see them. All of these statutory payments and the increases are effective as of the first Saturday in the month of April, which is the 6th of April. So, what should you do to make sure all of your statutory payments and minimum pay rates are correct? Make sure that all of your employees' hourly pay rates don't fall below the minimum wage for their age. Ensure that if you've got any employees who are on those family leaves, that you're paying them at the new statutory rates as of the 6th of April. Review and update all of your company policies and documents that mention the pound rate that they're being paid per week. Some of you may have got maternity policies or sickness absence policies or procedures that reference these weekly pay rates. Our advice would be to leave out those payment rates in any policies so that you don't have to update them on an annual basis. Makes sense, doesn't it? But we often see that these pay rates are in policies and they haven't been updated for many years. This next one is a bit of a big one, so forgive me. There's a lot of detail I need to go into here, and this might be one of those sections in our update for you that you're perhaps a bit confused about or you need some extra help with. So bear with me on this one. So this is all about the holiday pay calculations for part-time workers or irregular workers. And many of you small businesses will have part-time workers or people who work different hours every week. That's often something we see in smaller businesses because it's about affordability. You may not need a full-time person. A part-time person is a regular occurrence in a smaller business. So the definition for irregular hours workers and part-year workers, which these changes apply to, is if somebody works irregular hours for you the majority of the time, meaning they have to work a different number of hours each week, this would apply to them. They may have a casual hours or a 0 hours contract. A part-year worker is required to work only part of the year, and therefore there are periods in the year of at least a week during which they are not required to work and they're not paid. So a good example of this might be somebody who has a term time contract with you. So that means that they work when it's not school holidays. So they work for you during term time and then they don't work for you in the school holidays. The other example is possibly a seasonal worker. So you might have them working for you for 4 or 5 months of the year, and for the other 5 or 6 months of the year, you don't pay them. So this guidance also states that part-year workers may have fixed hours. So the irregular hours bit doesn't necessarily apply to people who work for you as a seasonal worker, for example, or a term time worker, because they may work regular hours, but only for the months that they're working. Make sense so far? Hopefully. So let's just summarize something about holiday pay calculations for part-time workers. So these are things that you should hopefully already be doing. All part-time workers or irregular hours workers have the right to receive their normal pay for 20 days holiday. So what's included with normal pay sometimes is where we see problems when we're working with clients. And this is particularly around bonus or commission arrangements. So, under the reforms, 4 weeks of the minimum 5.6 weeks paid holiday entitlement must be paid at a worker's normal rate of pay. Now, a normal rate of pay must include payments, including commission, that are intrinsically linked to the performance of the task that that worker is contractually obliged to carry out. So sorry for all the formality here, but just want to make sure people understand and we're being clear about what's meant by this. As well as any payments relating to perhaps professional or personal status relating to their length of service, their seniority, or professional qualifications. Payments such as overtime, which have been regularly paid to that worker in the 52 weeks preceding the calculation date, must also be included when calculating the normal rate of pay. A lot of information here to take on board. So let's just summarize this again. So they have to be paid for the 20 days holiday. I think that one's straightforward. You have to make sure that you are calculating their normal rate of pay, and that's generally over a 52-week period. And you have to include any additional payments that they regularly receive within that calculation of their normal pay over a 52-week period. Hopefully that makes sense, but this is often the one we have lots of questions about. So do feel free to drop us a line or call into that Ask Me Anything session on the 28th of March, and we'll gladly take your questions there. So we're now going to talk about rolled up holiday pay for irregular workers or part-time workers. Now, this is something that if any of you have been in business for a while, you may remember rolled up holiday pay. And it's been a big talking point because this was previously not allowed and ruled illegal. And the reason it was ruled illegal some years ago now is because people were paid an additional amount of money on top of their hourly rate, which was in essence paying them as though they were on holiday. Okay, so they got an inflated hourly pay rate to cover their holiday pay. What this actually did at the time was it meant people said, oh, I'll have that inflated hourly rate, but then I won't take any time off. And of course, as an employer, you have a duty of care to make sure your employees are taking the statutory amount of leave, which is 20 days per year plus 8 days bank holiday. So rolled up holiday pay was previously made illegal. You had to stop doing it. But guess what? They've done a total U-turn on this now, and now you can offer rolled up holiday pay. So, for leave years beginning on the 1st of April 2024, employers will be able to cover a worker's holiday pay through including an additional amount in their pay slips instead of paying holiday pay when the person takes annual leave. The calculation for this is 12.07% added on to the hourly rate of pay. Rolled up holiday pay, as I said, was originally ruled as unlawful by the European Court of Justice because of concerns that workers might be de-incentivized from taking annual leave. So let's summarise what you need to do around this holiday pay or the holiday pay changes for irregular workers and part-time workers. Make sure you are calculating all workers' holiday pay correctly. It's often an area we see done incorrectly, so really important that you get this right. When working out your employees' holiday pay, if they are entitled to overtime or bonus payments, then these payments need to be included when working out their average pay over a 52-week average. And again, this is an area we see time and time again. Employers are not including because clearly that inflates people's hourly rate. But if you're not doing this, you run the risk of receiving a claim for incorrect holiday pay being paid. If you do decide to operate a rolled up holiday pay, then there are a number of things you need to do that are your responsibility as an employer that will add to your workload. So You need to make sure you change your contracts to make it very clear whether a worker falls into the irregular hours or part-year worker category. But the most difficult factor is that you have to monitor that your staff are are taking the required time off, because you have that duty of care as an employer to make sure they're taking the statutory leave requirements. Now, if you have an HR system such as Breathe HR that records people's holiday and how much holiday they've taken, that's not a problem. But if you don't have something that is recording people's holiday, that's another lovely spreadsheet that you're going to have to manage and keep up to date. Okay, so right to work checks. Now, this is the big ticket item and one you really can't afford to get wrong. Now, I've personally been visited by the Home Office for a surprise audit, and trust me, it was an intimidating experience, but I'm glad to say that we passed our audit with flying colours. But, you do feel very kind of under the spotlight if that happens. You're very nervous about getting things wrong. And obviously, if you do get things wrong, I'm going to tell you about the increases in fines now, which makes it a really expensive mistake to make. So you'll know that all UK employers are required to check the right to work of their employees and take steps to prevent illegal working. I mean, that's just common sense. Civil penalties for illegal working cover the situation where a UK employer unknowingly employs an individual who does not have the required permission to perform the job they're doing. Now, the Home Office has announced that as of the 13th of February, so this is a couple of weeks ago now, the overall maximum civil penalty for employing an illegal worker will increase. And these increases are the big ticket items. So previously, if you've had one employee who didn't have the right to work documentation on file, you would have been fined up to £15,000 for that person. Now it is £45,000 per worker for a first offence. Yes, you heard me right. 45,000 per worker for a first offence. This is a huge cost, and a huge cost if you make a mistake. For repeat violations, previously you would have been charged a penalty of up to £20,000, and this is now increased to £60,000 per worker for repeat violations. Now you can obviously see the Home Office here are really upping the game. The likelihood is they are going to visit industries where there is a high likelihood of you having transient workers, people who are working from outside of the UK. So if you're, for example, in the hospitality or the leisure sector, perhaps if you work in IT, perhaps if you have skill shortages roles where you employ people outside of the UK, they will be coming to visit you. We know at least 2 of our clients who have had Home Office visits in the last 12 months. So they are happening, and they are targeting those companies with those kind of roles and from those kind of industries with skill shortages, because they know that you're likely to be employing people outside of the UK. So really important one to make sure you get right. So what should you do to make sure you don't get fined these awful amounts of money that the Home Office are going to potentially fine you? You need to make sure that you have the correct documentation on file for all of your employees, including UK nationals. Sometimes when we audit clients, what we see is they've got a copy of the passport, but they've not written on it who saw it, when, they haven't signed it. They haven't said original document seen. These are all really small points, but really important points when the Home Office, or if the Home Office come to visit, that's what they're going to be looking at. We will happily conduct an audit for you on your employee documentation to ensure you've got this right. There is an online right to work checking service available, which again, many employers are not aware of. This is available for you to use if you have employees working for you who are from outside of the UK. And here's the website. And I've realised that my picture is in front of that website. So if anybody needs the details of that website, we will give that to you, of course. The next change is the Protection from Redundancy Act, and this applies to people who are either pregnant or perhaps taking family leave. So pregnant employees or those returning from maternity, adoption, or shared parental leave will now be protected from redundancy. It will be your duty as an employer to offer these employees a suitable alternative vacancy in the 18 months after the birth or adoption. The existing right to be offered a vacancy while on any form of family leave will continue. So, what should you do about this change in terms of your business? Now, this shouldn't impact any of your policies. If you do have a redundancy policy, I'd like to think that it's not going to go into this level of detail. So your redundancy policy should still be okay. However, if you are considering making any redundancies or perhaps considering a restructuring exercise within the business, please make sure that you seek professional advice about this. But also make sure that you tell whoever is giving you that advice that you do have people within the business who are either on maternity leave, shared parental leave, adoption leave. It's really, really important that you make them aware of this. If you don't tell them, they can't give you the right advice about what to do. So the next change is about the Carers Leave Act from 2023. Now, currently, there is no dedicated statutory leave entitlement for any individuals who work for you, but they're also working at home, perhaps in the morning or in the evening, caring for a friend or a relative. There are no current leave requirements that support this person who's a carer. But from the 6th of April 2024, employees will have a statutory right to a week's unpaid leave to provide or arrange care for a dependent with a long-term care need. And this right is applicable from day one of their employment with you. So this new act grants carers 5 days of unpaid leave each year to fulfill their caring responsibilities. The 5 days can be taken as full days or as half days. Something that we are seeing more and more of is people having to care for relatives and children with special needs. As we have an aging population and care homes and things like that are incredibly expensive, many people are choosing to care for their relatives at home. And this is something that can impact people's attendance, people's performance, and their well-being if we're not supporting those carers. So what should you do as an employer then about this new carers leave that is coming into play? Number one, you need to make sure you have a carers policy in place. You also could consider whether you can afford to offer more than the 5 days of unpaid leave, or you could pay people who are carers to take 5 days of leave per year. Now, these are things that we're just suggesting. Of course, it's around affordability and what's practical for your business. But wouldn't it be nice if you could afford to do that? So there are some changes around the right to request flexible working. So this is an amendment to existing legislation. So you're probably aware that employees currently have the right to request flexible working, and this is currently from 26 weeks of service. But employees now have the right to request flexible working from day one of their employment with you. It was previously the 26 weeks of service that I mentioned. And there is also now an increased limit of making 2 requests per year, which also comes into force. Previously, people were only allowed to make 1 request in a 12-month period. So what should you do then about these changes? Well, you need to make sure that you update your flexible working policy to reflect these changes. So the next change is around the paternity leave regulations. So again, this is an amendment to current regulations because hopefully you've all got paternity leave policies in place because it's a statutory requirement that people can currently take paternity leave. So what's changing? Employees will now be able to take their 2 weeks of statutory paternity leave at any point in the first year of having a child. Previously, the leave had to be taken within the first 8 weeks of their child being born. And leave can also now be split into two separate blocks of 1 week each, whereas before you had to take the 2 weeks together and it had to be within the first 8 weeks of the child being born. So some considerable flexibility here around paternity leave. And if you remember earlier, we talked about the fact that the statutory paternity leave is going up to £184.03 a week. What we see is that many employers often decide to pay this leave at full pay during a period of paternity leave, given that the period of leave is so short. But again, like all of these things, it's about whether this is affordable and practical for you and your business. Now, I should also mention that these amendments are due to come into force on the 8th of March, but will only apply to children expected to be born on or after the 6th of April 2024. So, what do you need to do to make sure that your paternity leave regulations or policy is up to date? Obviously, you need to update it with the changes that we've mentioned. What can we help you with? So businesses need to stay up to date with the changes and the different implementation dates, especially where those changes will necessitate a change in policy or even creating a new policy. Whether you need advice on the changes, revising your policies, or training your managers or your HR teams, Meraki HR are here to help you. We can offer you with training, webinars, and one-to-one HR advice covering employment law and best practice. But best of all, we keep things simple and practical so that they work for your business. So if you need help with any of the new policies that we've discussed, we can provide you with a carer's leave, flexible working, and paternity policy for just £75 plus VAT. Now, normally they would cost £50 per policy, so there's a significant saving for you there by buying them as a package. We can also conduct an audit of all of your employee documentation to make sure you're doing all of the right things correctly in your business and highlight any issues for you, correcting any issues where we can. And the cost of that audit is £1,200 plus VAT. We can also conduct a right to work audit. And this is very dependent, the cost is very dependent on the number of employees that you have, because clearly it will take us much longer to audit 100 employees than it would 10 employees. So if that's something that's of interest, because that's the one that's got those big fines attached to it, then do get in touch and we'd be happy to provide a quotation on that for you. So if you need any of our help, please get in touch. We'd love to hear from you. And here's all the ways you can contact us. Thanks ever so much for listening. Bye for now.